Good evening everyone, I am Rina Gamba and I'm going to report the articles 1231 to 1237, Chapter 4, Extinguishment of Obligation. Now let's proceed to Article 1231. Obligations are extinguished. So paano nga ba na-extinguish ang obligation? How does it come to an end? Article 1231 enumerates the different modes of extinguishment of obligation. Ang mga concepts na ito ang iisa-isahin natin sa discussion sa chapter na ito. And these are: number 1, by the payment or performance, by the loss of the thing due. Number 3, by the condonation or remission of the debt. Number 4, by the confusion or merger of the rights of creditor and debtor. Number 5, by compensation. And number 6, by novation. Article 1232. Payment means not only the delivery of money but also the performance in any other manner of an obligation. So basically, first and foremost, dapat meron mo na talagang pre-existing obligation. Kasi kung walang obligation, ay wala rin namang babayaran. Example, si Kyla ay binigyan siya ng option to buy a specific car for 1 week. Pag hindi pa siya nagde-decide na bibilhin niya yung car na yun, wala pa siyang obligation. But once na nakapag-decide na siyang bilhin yung car, an obligation to pay on her part now exists, and in order to extinguish that obligation, Kyla needs to pay for the car. So ano bang sabi ni Article 1232 about sa payment? So si payment is not limited sa pagbabayad na alam natin ordinarily. In legal parlance, it has much wider meaning. Kasama dito ang performance ng obligation. Ibig sabihin, ang payment ay ang pagde-deliver ng pera o bagay. Pag real obligation or obligation to give, it also includes the doing and not doing of something. Pag yung obligation naman ay personal obligation or yung obligation to do or not to do. And like obligee and creditor, obligor and debtor, yung payment and performance are twin terms. Payment refers to obligation to give, while yung performance refers to obligation to do. For additional example, if Anna is obligated to give Race a specific car, payment is made by delivering the car. If Dan is obligated to repair Lisa's computer, payment is made by performing the service. That's it. So now let's proceed to Article 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as case may be. So this provision answers the question, when was the debt considered paid? So there are two requisites under this article. The first one is integrity of the prestation, and the second one is the identity of the prestation. Pag sinabi mong integrity of the prestation, meaning the prestation must be fulfilled completely. Dapat completely delivered or rendered. Hindi pwedeng partial or irregular, otherwise hindi ma-extinguish yung obligation. As we go further, we will find out na may mga exceptions of requirements itong integrity of the prestation. The first one is substantial compliance in good faith under Article 1234. The second one is waiver, that is under Article 1235. The last one is application of the payments if the debts are equally onerous under Article 1254. So in connection to the integrity of the prestation, here is an example. Sean promised to pay 10,000 pesos to Martin for the 10 sacks of rice, but Sean is only giving 8,000 pesos to Martin. Martin can refuse to accept the 8,000 pesos because the fulfillment is not complete. As for Article 1233, dapat buo ang bayad, hindi partial, hindi irregular. Kailangan ito ay buo. Kumbaga, buo mong hiniram, buo mo rin na ibabalik. Next is identity of the prestation, meaning the very prestation must be delivered or performed, kung ano mismo ang napag-usapang gawin or ibigay. Example, Martin obliged himself to deliver 10 sacks of sinandoming rice to Sean, but Martin delivered 10 sacks of NFA rice instead of sinandoming. The obligation is not extinguished. As for this example naman po, this may be considered complete if the obligation is not specific thing. So this may fall to integrity of the prestation, but since the thing is a specific thing, we have to consider and follow kung ano yung hinihingi. Sino ba yung may burden of proving payment? So at first, si creditor ang may burden of showing na merong valid debt or may obligation na nag-i-exist. Pero once na-establish na may obligation nga, si debtor ang may burden of proof na nabayaran niya na. It is the debtor who has the burden of showing with legal certainty that the obligation has been discharged by payment. Again, hindi si creditor ang may burden of proof to show na hindi pa siya nababayaran. Instead, si debtor ang dapat mag-prove na nakapagbayad na siya. And one good proof is the presentation of receipt. Proceed to Article 1234. If the obligation has been substantially performed in good faith, the obliger may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. This is also known as the substantial performance or compliance in good faith rule. Again, this is one of the exception of the integrity of the prestation, which is under Article 1233, na dapat ang payment must be complete, buo ang bayad to extinguish the obligation. Dito, recovery is allowed in case of substantial performance in good faith. So may dalawa itong requisites. The first one is substantial performance and the second one is in good faith. Hindi pwedeng substantial performance lang, dapat in good faith rin. That's why it's called substantial compliance in good faith. So for example, Gian obliged himself to send 1,000 bags of cement to Athena for a certain price. And then, despite diligent effort on the part of Gian, hindi niya na-deliver yung 1,000 bags of cement. Talagang 950 bags lang ang kaya niyang ibigay dahil nagkaroon ng shortage of cement. So take note, si Gian gusto niyang i-comply yung obligation to deliver 1,000 cement bags. Pero hindi niya magawa for reasons outside or beyond his control. Kasi diba, wala siyang pagkukunan, nagkaroon ng shortage. So, ibig sabihin, he acted in good faith naman. So, Article 1234 provides or tell us that Gian can recover as though there had been complete delivery. So, ililess lang yung price ng 50 bags na hindi niya na-deliver. So meaning, Athena cannot require Gian to deliver the remaining 50 bags para makompleto yung 1,000 bags bago siya magbayad. Kasi meron namang substantial compliance in good faith. So babayaran niya ni Athena dapat si Gian, although ililess yung price ng 50 bags na hindi niya na-deliver. In short, Athena must pay the 950 bags and then less the 50 bags na hindi na i-deliver ni Gian. So in short, Athena must pay for the 950 bags and enforce her right to damages for failure of Gian to deliver the remainings. That's it. So now let us proceed to Article 1235. When the obligation accepts the performance knowing its incompleteness or irregularity and without expressing any protest or objection, the obligation is deemed fully complied with. So again, this is another exception of integrity of the prestation under Article 1233 na dapat ang payment ay kumpleto. So despite fully knowing na incomplete or something is irregular in the payment, ngunit tinanggap na rin ni creditor without expressing protest or objection, then the obligation is fully complied with. This is based on the principle of estoppel, meaning you are now estopped to question. Kasi nung nagbayad, hindi ka naman umangal o nagreklamo. Tinanggap mo nang walang signs of protest or objection. It's as if nag-waive ka ng right mo. Kasi diba nga, supposedly, kapag incomplete, pwede mong i-reject ang payment. Pero with knowledge na incomplete or irregular yung payment and you accepted it, then the law presumes that you are waiving your right to accept the payment even though it's incomplete. Sa article na ito, dalawa ang dapat tandaan. The obligee knows that the performance is incomplete, and second is he or she accepts the performance without expressing any objection. As used in this article means to take or agree to an incomplete or irregular payment. So question, may required form of protest ba? Actually po ay wala. Article 1235 does not require that the protest or objection of the creditor to be made in particular manner or particular time. As long as gumawa ka ng act which clearly shows na you are not agreed to the said payment or performance, the obligation shall not be extinguished. Example, Kyla availed of John's services to stencil the name of his business on 3,000 pieces of rosary for donation using a particular font size. John delivers the 3,000 pieces of rosary with a stencil on each but using a different font style. Kyla received the rosaries and distributed them to the donees. Obligation is extinguished. So in this article, Kyla didn't do any protest about the works of John. That's why the obligation is extinguished. Another example, Zach avails of Daniel's service to renovate his house for the purpose of making it soundproof. Daniel renovated the house but the soundproofing was not good enough. Zach texted Daniel that he is not satisfied with the latter's work. Obligation is not fully extinguished kasi nag-protest si Zach about sa service na ginawa ni Daniel. That's why it's not fully extinguished. And nakadepende na yun sa agreement na ng dalawa kung ipapagawa niya ulit kay Daniel yung pagre-renovate ng soundproofing or hindi na.
Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except if he paid without the knowledge or against the will of the debtor. He can recover only insofar as the payment has been beneficial to the debtor. So, the first paragraph provides a rule kung kaninong payment yung dapat i-accept ni creditor at kung kanino yung hindi niya dapat tanggapin. So, first, syempre kay debtor kasi siya yung may utang. So, natural, sa kanya siya dapat tumanggap ng payment. Second, ay si person who has an interest in the obligation. So, sino ba tong person who has an interest in the obligation? Example nito is yung guarantor. And last, si creditor is bound to accept payment to the third person who has no interest in obligation. When there is a stipulation that he can make payment, pwedeng tumanggap si creditor sa third person basta ito ay nasa stipulation or agreement. Next, paragraph 2. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can only recover insofar as the payment has been beneficial to the debtor. So dito, pinapaliwanag kung ano yung magiging epekto ni third person kasi wala siyang interest pero gusto niyang magbayad. So ano ba yung epekto nito? So kapag yung payment ni third person is with the debtor's knowledge and consent, si third person is entitled to demand from the debtor what he has paid, either reimbursement or subrogation. So ano ba tong subrogation? The payer steps into the shoe of the creditor. He is now entitled to exercise all the rights and actions na pwede at available gawin ni creditor. Now, paano naman kapag yung payment is without the debtor's knowledge or against the will ni debtor? He can recover only insofar as the payment has been beneficial to the debtor. So, meron lang siyang beneficial reimbursement. Wala siyang subrogation. He is not entitled to subrogation. So, si third person can recover only payment to the extent that the debtor was benefited. The recovery is only up to the extent to the amount of the debt at the time of payment. Example, Mark owes Samantha 1 million pesos. Tapos itong si Zoe, who is a third person, offers to pay the 1 million pesos. Dito, may right to si Samantha to accept or not to accept the payment because Zoe is not the debtor after all at wala siyang interest sa obligation. Wala din sa stipulation nila na pwedeng si Zoe ang magbayad in behalf of Mark. So let's suppose that Samantha accepts the payment of Zoe. So question, can Zoe recover from Mark? If so, how much? So the right of Zoe to recover from Mark depends upon whether the payment with or without the knowledge of Mark. So kung without the knowledge of Mark or against the will of Mark and the actual indebtedness is 1 million pesos and Zoe paid 1 million pesos, then Zoe can ask the reimbursement for 1 million pesos. Pero if unknown to Zoe that Mark already paid the half of it, which is 500,000 pesos, such that 500,000 pesos na lang talaga yung utang ni Mark kay Samantha. So Zoe is entitled to reimburse only the 500,000 pesos kasi yun lang naman yung amount kung saan naka-benefit si Mark. Zoe can recover the other 500,000 pesos to Samantha, who's in the first place should not have accepted the payment when in fact she is well aware that Mark already given her the half of the 1 million pesos. That is the case of solutio indebiti, yung unjust enrichment. So another scenario, this time may consent naman ni debtor or ni Mark. So if it's with the consent of Mark, then Zoe can recover to Mark the 1 million pesos with all the rights of subrogation to the successory of the obligation. If ever merong mortgage guarantee or penalty, the third person who pays someone else's debt has the right to reimburse and subrogation, to recover what he has been paid, and to acquire all the rights of the creditor. So let's proceed to the last article of my report, Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from mortgage, guarantee, or penalty. So ito na rin yung sinabi and na-discuss natin kanina. And this is expressly provided under Article 1237. If si third person nagbayad without the knowledge of the debtor, he cannot compel the creditor to subrogate him in his rights. So this was discussed earlier. Yun yung si third person is put into the shoe of the creditor kasi na-acquire niya na yung right ng previous creditor. So let us just distinguish subrogation to reimbursement. Dito sa subrogation, meron siyang recourse, meaning recourse is the legal right to demand compensation or payment. While dito sa reimbursement, walang recourse, so walang legal right to demand compensation or payment. The debt is extinguished in one sense but the new creditor, with exactly the same right as the old one, appears on the scene. Dito, nawala na yung obligation pero may bago ng creditor with the same right. Exactly the same as the previous creditor kasi siya na ngayon yung mag-exercise ng right na meron doon kay previous creditor. New creditor has different rights. Dito naman sa reimbursement, si new creditor has different rights. Hindi niya ma-acquire yung kung anong merong rights sa subrogation. Tapos, there is more than personal action of recovery kay subrogation. While sa reimbursement, there is only personal action to recover the amount. So, to sum this part up, si reimbursement, more of recovery of payment siya. While si subrogation, may recovery of payment at the same times, may na-acquire rin siyang mga rights. That's it. I hope you learned from my report. Thank you for listening. God bless and be safe, everyone.